Well, good afternoon and welcome to the George Washington University Law School. I'd like to welcome all of you on behalf of the faculty and the staff. We're delighted that you could be here for this debate on the same-sex marriage cases. I'm especially thankful and grateful to our Associate Dean for Public Interest, Public Service, Alan Morrison, a Supreme Court advocate who has put together this panel presentation. I'm also thankful to our two guest speakers, Ed Whelan and Paul Smith, both of whom will be introduced to you by Alan Morrison. We're really glad that we can have these kinds of debates on this campus. I hope you'll attend other ones that Alan's organizing in the near future. Thank you very much. Alan?
Thanks, Greg. Welcome to everybody here. I want to introduce our two panelists. You have a program that describes their history in detail. Both of them have filed amicus briefs in the cases now pending before the court. To my immediate left is Paul Smith. Paul is a partner at Jenner & Block here in Washington, D.C., and among his many notable achievements, he was the victorious counsel in Lawrence against Texas. To my right is Ed Whelan from the Ethics and Public Policy Center. Ed is a longtime conservative activist in the Reagan administration. Also worked on in the what's it?
I wasn't Reagan.
Bush.
Bush.
Excuse me.
Not that old.
Not that old. All right. And has also filed an amicus brief in the case. More of their bios are in the program in front of you. So let me begin by be sure we're all on the same page about these two cases, and they are quite different. The first case I want to talk about is the one that's going to be argued tomorrow. It's called Hollingsworth against Perry, and it began when the California Supreme Court ruled that as a matter of California state law, the laws banning same-sex marriages were unconstitutional under the California Constitution. Immediately, an initiative process was begun, and in November of 2008, the voters of California passed an initiative, an amendment to the Constitution that said marriage shall only be between persons of the opposite sex, one man and one woman, outlawing same-sex marriage. At the same time, California had already in place, well before the first decision, statutes that created domestic partnerships that provided all of the legal rights to same-sex partners as marriage did, but they could not call themselves married. The reaction was fairly prompt. The case was filed in the federal court after an unsuccessful case in the state court, challenging the constitutionality, this time under the federal constitution, of the ban on same-sex marriages. The governor of California and the attorney general, who were the named defendants, declined to defend the statute, the initiative, excuse me. And as a result, the proponents of Proposition 8 came in and defended the case in the merits, including the trial before Judge Walker in the Northern District of California. After the trial, Judge Walker ruled on both due process and equal protection grounds that the law was unconstitutional. Whereupon an appeal was taken by the proponents. The governor and the attorney general did not appeal, which, as you'll see in a moment, caused some difficulties. In the Ninth Circuit, a question was raised as to whether the court had jurisdiction, that is, whether there were proper parties before the court, and the court referred the case to the California Supreme Court, which ruled as a matter of California law that the proponents of the initiative were proper parties to defend the statute when the attorney general and the governor did not. The case then went back to the Ninth Circuit, and the Ninth Circuit decided that the law was unconstitutional as a violation of equal protection. Unlike the district court, which ruled on both due process and equal protection, the Ninth Circuit ruled on equal protection, and it did it on a very narrow ground, on the ground that because California once had same-sex marriage as a matter of state constitutional law, it was subject to a higher standard when it tried to take away that right, and the state had not met that standard. En banc review was sought, and it was denied, and the case then went to the Supreme Court, which has agreed to hear the case, including the issue as to whether there's a proper jurisdiction. The problem being, of course, that the proponents do not have standing in the ordinary sense of the word. That is, they're not directly injured as the state defendants would ordinarily be. And so the court will hear that question first on tomorrow when it hears the argument. In the meantime, the Solicitor General of the United States has intervened on behalf of the challengers to the constitutionality of Proposition 8. The second case is different. In this case, the plaintiff, Edith Windsor, was legally married under the laws of the state of New York to her spouse. And when her spouse died, the IRS decided that because of the Defense of Marriage Act, which says that for federal law purposes, a person is married only if they're married to a person of the opposite sex, that she had to pay the estate tax, because the estate tax can only be forgiven if parties are lawfully married, and as a matter of federal law, as a result of the Defense of Marriage Act, which was passed in 1996, which says that only opposite-sex marriages are valid as a matter of federal law, will the would the tax be forgiven. The case that is going to the Supreme Court will be heard on Wednesday is one of many Defense of Marriage Act cases. The plaintiffs have prevailed in all of them in a number of different jurisdictions, and the court chose this one as well. Originally, the Justice Department defended the constitutionality of DOMA, and then after it lost in the district court, it decided not to defend the constitutionality. It decided that a heightened standard of review was applicable, and under that heightened standard of review, DOMA could not pass constitutional muster. When it did that, and it did it at the district court level in the Windsor case, which is before the court now, the House of Representatives, through an entity known as the Bipartisan Legal Advisory Group, entered the case to defend on behalf of the House, claiming that the law was constitutional, which meant that at least there would be an adversary presentation, which there was in the Court of Appeals in this case. And the Court of Appeals, by a vote of 2-1, applying heightened reviews, struck down the law, and the case is now before the court. When the court granted review, it did something quite interesting. Although both the House and the Solicitor General, as well as the plaintiffs, all believe that there's jurisdiction, the court independently raised the question of whether there's jurisdiction or not, and it appointed a Harvard law professor, Vicki Jackson, to appear as amicus to argue that everybody else is wrong and that the court has no jurisdiction and cannot reach the merits of the case. The plaintiff will prevail in terms of getting her $356,000 plus interest back in either event. But the real question is, what will be the impact of it beyond the plaintiff? And the same may be true in the Prop 8 case, that the 4 plaintiffs there who were held by the district court to be entitled to an injunction ordering the state to grant them a marriage license, they will certainly be entitled to get a marriage license if the decision is upheld, even if it's set aside on grounds of lack of jurisdiction. The question will be there, and in the DOMA case, what other impacts will it have? All right, that's our very quick trip. Ed, Paul, any other thoughts on the jurisdiction or other facts that our audience should know about before we proceed?
Well, let me mention one aspect of the Prop 8 standing that Alan didn't have a chance to get into, and that is that the specific holding of the California Supreme Court was that the Prop 8 proponents represent and are entitled to assert the interests of the state in the litigation. The court did not reach the separate question that the Ninth Circuit had certified to it, whether the Prop 8 proponents had a particularized interest. But precisely because the Prop 8 proponents have the interest of the state, I think it's clear that they will prevail on the standing issue, and the court will be deciding the case on the merits.
Boy, I really disagree with that.
Good.
I don't have any. I'm not predicting standing will be the basis of the decision, but I think there's certainly a significant possibility of that. Both because I think that the exact status of the proponents, as a matter of federal law, and whether they really speak for the state in the way that they have to in order to have Article III standing based on the state's injury, is clear enough. And there's a very persuasive, at least some people think persuasive, brief by Walter Dellinger that talks about that problem. But also because it's if the court or the center of the court were looking for a way to avoid deciding the biggest questions it could reach in the case, that would be a very easy way for them to do it.
You think there's clear law on this, Ed, or do you think that the California Supreme Court's decision makes it very difficult for the Supreme Court to not reach the merits of these questions?
Well, I think the California Supreme Court holding fills the gap that the Supreme Court in dictum, the U.S. Supreme Court in dictum, had recognized in a case called Arizonans for Official English, I believe.
Yeah.
Basically saying that now we have the Prop 8 proponents who are acting on behalf of the state, and that's sufficient. Here we have an initiative that state officials are refusing to defend. So I don't mean to be predicting what the court will do, but I think it ought
that's the right
to.
answer.
Yes.
And do you think it matters that they went to the California Supreme Court, sort of to speak, to get permission, if that's what they got, only after they had defended it and taken an appeal? Do you think the timing matters in any respect?
No, I don't think it does. I mean, the Ninth Circuit certified the question to the California Supreme Court because the California Supreme Court is the authoritative interpreter of state law, and I don't think that it really would have made sense for it to have been done at any earlier point. At least if your account of what happened in the district court proceeding is right, that is, there was sufficient adverseness there, there would have been no reason for Judge Walker to certify that question to the California Supreme Court.
The thing that's kind of murky about their status is that they're the proponents. They were the official proponents of the initiative, but it's not like they're designated that they could speak for the state, bind the state, do the kinds of things that a special attorney general could do. You end up, if this theory is accepted, that they have standing with the weird situation that 80 years from, or 40 years from now, whichever one's left alive could still be defending them. Or maybe you have this other problem, which is there's 5 of them, and they could disagree about how to defend it, and there's no process by which any of this could be sorted out. So I could imagine a court decision that says, look, if you want to have private citizens representing the state in a situation where the elected officials are not doing their duty to represent the state, you have to have at least some kind of deputizing procedure that says, here's the people, they will bind the state with the representations they make in court, which is not at all clear now. And here's how they decide what the position they're going to take, who the decider is, and all of that.
And that would have to take place before the case was litigated.
Well, before the appeal was brought. Yeah, that's right.
Certainly.
Yeah.
Well, the quandary, of course, is that the initiative process is designed to bypass obstruction of state officials. And it's very strange to then have these obstruction of state officials be able to undermine.
So let me ask you this question, because I know you've written about this and talked about this. Do you think that the officials, both the federal and state officials, in both of these cases, were right to refuse to defend these statutes?
No, they were derelict in their duty. They were irresponsible in not carrying out the duty they were constitutionally charged to do. I think if you look at the Obama administration in the Defense of Marriage Act cases, first the Obama administration sabotaged its defense of the cases it was pretending to defend by abandoning arguments that had prevailed in previous DOMA litigation. Then, contrary to the practice that had been adopted across administrations of both parties, it claimed that it had some basis for no longer defending the Defense of Marriage Act at all. And again, likewise in California, you had Governor Schwarzenegger and then Attorney General Brown fail to live up to their responsibilities. That failure on the part of elected officials to do their job creates complications, and that may explain why we don't have too much precedent in this area. And I certainly agree with Paul. There can be some, weird hypothetical situations down the road. But I think that in both cases, there's ample precedent that will enable the court to reach the merits.
Paul? Any thoughts about the rightfulness of the refusal to defend either or both of those cases?
It seems to me that the minimal thing that you ought to expect of people in this position is that they file the appeal and therefore make sure that the case gets up to the highest authoritative court and to decide the merits of the case. The decision that the Obama administration made to continue to enforce DOMA and to bring it all the way to the Supreme Court simply said, we are going to give you the only constitutional analysis which we think is defensible. And they did this at a point in the litigation where cases were being filed not in the First Circuit but in the Second Circuit, where there was no law of the circuit on the question of whether heightened scrutiny applies to discrimination based on sexual orientation. And when you sit down and actually try to answer that question based on first principles of what the rules are, it's extraordinarily difficult to mount an argument that says that discrimination based on sexual orientation ought to be presumptively constitutional, that it's just subject to rational basis scrutiny. And so they came to the lawyer's conclusion that they couldn't make that argument. And then the only other argument they could make was that DOMA satisfies intermediate or strict scrutiny under the Equal Protection Clause, which is, frankly, something that nobody's tried to argue except in a passing, because it's just in defense. It's not arguable. The law is so close to just plain flat out irrational that it doesn't even come close to satisfying heightened scrutiny.
Now let's. I want to turn to the question. Paul said some magic words, and not all of the students in the room here, and certainly not the audience, understands advanced constitutional law and knows what heightened scrutiny is all about, and intermediate scrutiny and rational basis. Paul, can you give us a little bit of a primer on that?
So under the 14th Amendment, there's an equal protection clause that says you shouldn't deny equal treatment to different groups of people. The law, on the other hand, draws distinctions among groups of people all the time, quite properly so. People who speed pay money in tickets. People who don't speed don't pay money in tickets. Is that something that is viewed as discrimination? No. So what the law does is it says certain kinds of discrimination are subject to extra heightened scrutiny because they're basically viewed as presumptively bad, presumptively based on illegitimate prejudice or animus or other kinds of criteria like that. Whereas virtually all the other lines that the law draws between groups of people are viewed as presumptively constitutional and subject only to rational basis scrutiny, and in most instances that means that they're upheld. And so the first question you have to ask when you're applying the Equal Protection Clause in these cases is, are we going to view this as like racial discrimination and gender discrimination and discrimination against aliens, or are we going to view this as economic regulation, or is there some third category somewhat in between, which the law has started to follow in recent decades? But it's all about ratcheting up the level of scrutiny.
And what's the effect of higher degrees of scrutiny, Paul, in terms of being able to defend the law?
Well, in order to defend a law that's subject to heightened scrutiny, you have to come up with not just a rational justification, you have to come up with a very substantial or compelling justification. It has to be the real reason the law was passed, not just a hypothetical reason. And there has to be no less restrictive way to achieve that same purpose. So that basically what that means is it's a very difficult obstacle course for the defender of the law to get through and succeed in persuading the court that the law should be upheld.
So the challengers are trying to get heightened scrutiny, and the federal government has come in now in both cases and said they're entitled to some degree of heightened scrutiny.
Right. This basically say at a minimum it ought to be treated the same as a law that draws a distinction between people based on their gender.
All right, Ed, do you accept that as the general proposition before turning to the question of whether sexual orientation ought to be treated like gender and alienage and so forth?
Well, I accept at a very general level Paul's distinction between rational basis review and heightened scrutiny, of course.
A level of generality, as my students will remember me saying from time to time.
I think we see a lot of malleability in both standards that judges have introduced, and I would contest whether there's any real intellectual integrity at all to heightened scrutiny. But the more important point I think I'd make is when you're dealing with something like marriage, male-female marriage, which has been around in all states in this country since the Constitution was first adopted, was in all states in this country at the time the post-Civil War amendments were adopted. I don't think you need to even get to the standards of review that lawyers can get tangled up in. By the idea that traditional marriage has been unconstitutional since 1868, I think is far-fetched. Now, let me be clear. We need to distinguish constitutional views from policy views, and there's a robust debate going on in this country about whether states and the federal government in its realm should redefine marriage to include a right to marry a person of the same sex. That's a proper discussion and debate to go on. My view about the Constitution is it doesn't speak one way or the other to the question of same-sex marriage. It leaves the matter to the political processes for decision. It's permissible for the people to retain traditional marriage laws. It's permissible to revise them. But I think when we look, again, at the history of marriage in this country, the idea that judges now are going to play around with these levels of scrutiny and determine that something that is so clearly established everywhere as constitutional, as accepted, is now suddenly going to be thrown out the window. I think there's something wrong with standards of scrutiny if we wield them in that that way.
It suggests a certain degree of fear of the level of scrutiny that one would apply if you would just apply the rules. I mean, the move Mr. Whelan just made here is to go straight to the justifications and say that's the reason why we shouldn't have any scrutiny in the first place. This is when you decide what level of scrutiny you're going to apply, you don't look at the particular law at issue and say, is this a good law or a bad law? You look at the category and say, if we're going to have laws that say straight people get benefits and gay people don't, is that something that we would ordinarily think is presumptively good or presumptively bad, presumptively based on history of prejudice, or presumptively reflecting real differences between these two groups of people and how they can contribute to society? Is it like racial discrimination and gender discrimination, which most of the time is not a good thing, or is it not? And the answer is, I submit, clearly it is, that this is a group of people, just like racial minorities, just like ethnic minorities, just like women, who have a long history of being kept in oppressive conditions, who have a characteristic which is very core to their beings, which is completely irrelevant to their ability to contribute to society, and they don't have enough numbers to protect themselves from the majority, which in most places in this country has passed constitutional amendments in the last 10 years designed to prevent them from ever having a chance to have marriage equality. Now that is a situation that calls out for heightened scrutiny, and if you just apply the rules, that's what you get. Then the question is, well, under heightened scrutiny, does a law that continues to discriminate against gay people in marriage rights have justifications, and what are they, and are they sufficiently compelling? But that's the next level of the analysis, and I don't think you should mix them together.
Well, I have no fear at all of how the court's accepted standards of review ought to apply here. I'm simply making the point that there is a bit of a judicial power grab going on in the way these standards of review, especially in how malleable they are. But I'm happy to address why, if we do look to these standards, rational basis review ought to apply. Rational basis review has been explained by the Supreme Court as a paradigm of judicial restraint. City of Cleburne case, where individuals in the group affected by a law have distinguishing characteristics relevant to interests the state has the authority to implement, the courts have been very reluctant, as they should be, to use heightened scrutiny. Now, we haven't, we've been talking for several minutes now about these cases without discussing at all what marriage is, what the purpose of marriage is, and why it exists. And if we look at those fundamental questions and then think about the standards of review, I think the answers become quite clear. Why did marriage develop in this society and elsewhere in the world? Marriage exists in order to channel the procreative capacity of opposite-sex couples in order to find a way to raise and civilize the little barbarians that come out of the womb and transform them into productive citizens. That is the primary mission of marriage. It is the reason that marriage exists. It explains why the male-female component of marriage has always been at its core. That can be changed. Again, I think it's constitutionally permissible to change it. But once you understand that and see that that is what is at the core of marriage, I think the case becomes very easy.
Paul?
Well, I think what happens with constitutional law in an area like this is that the principles that were established in 1868 are still there to be invoked by new groups of people as their situations arise over time. And the one thing that has changed since 1868 is that we now have hundreds of thousands of gay couples out there living long-term relationships that, as the Supreme Court in Lawrence said, have the same functional importance for them as marriages, raising children, living in their communities, contributing to society. That reality then has to be taken into account in deciding whether or not, under the Equal Protection Clause, there is a sufficient justification for not changing what has been the traditional definition of marriage. It's not that we have a fight about whether or not there's been marriage for same-sex couples throughout history. It obviously hasn't. But the world is a different place. And under the enduring principles of the 14th Amendment, this group of people, gay people, have the same right to call upon the courts for protection from what has become an oppressive situation as everybody else. And I don't see any basis for suddenly saying, well, we're going to draw up the ladder. Black people got it, ethnic groups got it, women got it, but boy, those gay people, they're too late. No more heightened scrutiny for you. You're just going to have to fight it out in a democratic process. 5% of the population, but you're going to have to fight it out in a democratic process.
Paul, I find your argument surprising. I mean, there are gay people 100 years ago. Do you think that the rights of gay people today are the constitutional rights are greater than those 100 years ago?
I do. I think constitutional rights, especially rights against discrimination, take into account the reality of how people are living. and the whole world is different now. There are gay families living in long-term relationships in neighborhoods down everybody's street, and I think that to suggest that somehow we're going to go back and do this, what did Thaddeus Stevens think about gay marriage in 1868 is the way we're going to answer this seems wrong to me.
Well, what seems wrong to me is the notion that the democratic processes are not the proper forum for accommodating exactly the change that you're describing. I mean, why we cannot, in our different states and in the federal realm through Congress decide and revisit over time how we ought to address this. I mean, that is what I think a constitutional republic is all about. Not thinking that judges have the authority willy-nilly somehow to impose their own view and upset the central social institution of American society.
What makes it a constitutional republic as opposed to a pure democracy is that there are constitutional rules which constrain the majority and say, sure, you can do most things by democratic vote, but there are some things you can't. And what we're talking about here is whether or not, if you look at the way the principles of the Equal Protection Clause work, is this a group of people who ought to be able to invoke it in the way that other people have in similar situations going back in history? And I think that the argument is extremely compelling. If you basically buy the proposition, which is the core ruling of Lawrence v. Texas, that the government has no business telling gay people that they shouldn't live together and have sex together, that's their choice and it's not the government's choice, and the moral intuitions of people who dislike that are irrelevant to law. Once you buy that, then given the situation we now have with tens and thousands of children of these families living there without the benefits of having married parents, I think that the constitutional argument for not just letting the democratic process go forward is a strong one, particularly when it's easy to say, well, things are moving fast. Look at California. They would probably repeal Prop 8. There are more than 30 states out there that require you to overcome a state constitutional amendment to get marriage equality, precisely because they don't want this small minority of their citizens to have any real opportunity to use the democratic process to get their needs met. That's exactly what that was done for.
One quick point, Paul. As you know, state constitutions are easy to amend.
Some are, some aren't.
Okay, but they were amended to become the way they are. They could easily be amended the other way. It's not as though the federal constitution, of course, is very, very difficult to amend. I think too many people use that as a model to make people think that it's so difficult at the state level.
All right, so I want to turn to a sub-issue under this heightened scrutiny, and that is one of the tests that has been on applying heightened scrutiny is whether the group is characteristics that are immutable. It's been said that what is the state of the record of these cases, and what is the status of knowledge about the immutability of sexual orientation, and should that be a deciding factor in any respect?
Well, the science is such that for most people, gay people and straight people, their sexual orientation is largely not subject to change. The professional groups who file briefs in these cases, the psychologists, the psychiatrists, and everything would tell you that efforts to change your orientation one way or the other through therapy will not succeed in most cases.
Was that issue tried in the California case, in the Prop 8?
There was certainly testimony about that, yes. But
whether he made a fact-finding?
I don't remember, frankly, Alan, whether there was a fact-finding or not, but it's at least largely undisputed. Now, there are people who are bisexual and go back and forth, and it's not that for everybody orientation is all one way or all the other way. I mean, Kinsey had his spectrum and things like that. But it is largely true that whatever you are, you are. Nobody's 100% sure whether it's how much of it is genetic, how much of it is nurture, but it is a characteristic which is very difficult to change. The other thing I would say about this, when you look at it this way, the real question ought to be is this something that people should be required to give up in order to be able to be treated equally, is the question. And I don't think anybody can look at that and say a person who knows that they're gay ought to be required to live a straight life in order to have full equality under the law.
Alan, if I may, I think you've jumped ahead a little bit. I'm happy to jump right into this. But I think in terms of heightened scrutiny, one first needs to understand that the court has made clear that absent a clear basis in the Constitution, the court should be very reluctant to establish new suspect classes.
But it hasn't said in the Constitution it has to be there like race or gender, for that matter.
Agreed.
Okay. I just wanted to be sure everybody
And
understands.
I think the most important of the four components the court has identified is political powerlessness.
All right, I'm glad to talk about that.
Which I think we can turn to perhaps after I respond to
Absolutely.
Paul's points
That was next on my list.
about immutability. I'm going to cite here statements by plaintiffs' experts in the Prop 8 case. This is all from the people that the opponents of Proposition 8 called as witnesses. And first of all, the definition even of sexual orientation is disputed by the other side's experts. Is it behavior? Is it desire? Is it identity, self-identification? Plaintiff's expert in the Prop 8 cases found that among individuals who reported some degree of same-sex behavior, desire, or identity, the three categories overlapped, only for 24% of men and 15% of women. Plaintiff's experts also have stated that sexual orientation may vary throughout the course of a lifetime. Female sexual development is a potentially continuous lifelong process in which multiple changes in sexual orientation are possible, such that the concept of erotic plasticity is the cornerstone of a new paradigm for understanding women's sexual orientation. Those obviously aren't my words. That's some social scientist.
Yes. Doesn't sound like a lawyer talking to me.
Yet another. We don't really understand the origins of sexual orientation in men or in women. And the American Psychiatric Association's 2009 stated that to date there are no replicated scientific studies supporting any specific biological etiology, which I believe is a fancy word for origin, for homosexuality. Now, I don't claim to understand much at all about the scientific issues of sexual orientation. What is clear to me is that the scientific evidence is radically inconclusive on this, and there's simply no basis, no scientific basis for the statements made by the other side in the briefs that this is somehow immutable or I think as Ted Olson put, people are every gay and lesbian is determined that way at the moment of birth and doesn't change at any point thereafter.
The vast majority of gay men know they're gay men and stay gay men their whole lives. Women, it's still a large majority, but it's a somewhat smaller number. There's a somewhat larger degree of fluidity. But if you think that sexual orientation is something that's just wanders around, think if you're a straight person out there, just think of what are the odds you're going to wander into being gay when you're 30? What do you think of the odds of that?
It evidently happens a lot.
No, it really doesn't.
Well,
so one of the questions I want to ask is, if the Supreme Court is going to be asked to rule on this case, and one of the issues is immutability or something close to immutability, should we have a trial on this?
Ultimately, I think it's not the kind of question that ought to be treated this. It's not a scientific question. It's a question ultimately of values. Is this a characteristic that's core to a person's being, that's likely to be something that will be part of their being for over a long period of time? Or to put it in a different way, is this something that people should be required to give up in order to be treated like everybody else? And the key, it isn't by any means the most important of the criteria, but it is that's I think how you ought to think of it.
So it ought to be rather than actually is immutable, perhaps. All right, Ed, let's go to political power, which you want to have as a significant factor. We're not going to pin you down as to whether it's the most significant and how you weigh it. But
well, you don't need to pin me down. I've said that. Yes, it's the most significant.
The most significant.
Because the very question that the court is deciding is, when do you remove something from the ordinary democratic processes? When do you have the court intervene on behalf of this politically powerless group? And what the court said in the city of Cleburne said, in that case, the legislative response negates any claim that the mentally retarded, the group in that case, are politically powerless in the sense that they have no ability to attract the attention of the lawmakers. So here's the test of political powerlessness: no ability to attract the attention of the lawmakers. Well, I think any realistic assessment of political power in this country now shows that gays and lesbians have, it's a credit to their lobbying, the case they've made, they've amassed tremendous power. The Human Rights Campaign, I think, has been ranked as the second most effective lobbying organization. You see how the Obama administration has basically been bent to do the will of the gay and lesbian groups in the DOMA case and Don't Ask, Don't Tell. As
Prop 8 too. They came in Prop 8 too.
Absolutely. As Paul Clement summed it up in his brief here, he says that gays and lesbians are one of the most influential, best connected, and best organized groups in modern politics, and have attained more legislative victories, political power, and popular favor in less time than virtually any other group in American history. Now, that's something that gays and lesbians, have good reason to celebrate. But to then come into court here and to claim that they're politically powerless and that they need to have the special benefit of heightened scrutiny, I think that just doesn't wash.
For a whole variety of reasons, everything he just said makes no sense. It seems to me, first of all, the standard that he would apply, can they attract the attention of other people in the political process? Under that standard, we'd have to get rid of heightened scrutiny for black people, for women. Obviously, all of those groups have at least as great an ability to attract the attention of others in the political process. Second of all, but more importantly, the whole idea that somehow, because the Obama administration happens to be more sympathetic than the Bush administration, somehow the constitutional law is going to change is somewhat inconsistent, I think, with Ed's view that the Constitution is an immutable thing going back to 1868. Under that theory, in 1965, when you could be fired from every public employee job in the United States if you were found out to be gay, then all of these laws were unconstitutional, and everybody had a constitutional right to marry their same-sex partner. But now they don't, because suddenly, in a few states, they have pushed it through. That can't be the right way to think of it. The reality is, if you look at what factors are really important, and the Supreme Court is very clear on this, it's neither immutability nor political powerlessness. It's the other two factors, which is this a group that has a long history of being oppressed and being subject to bigotry and prejudice? Yes. And is the characteristic we're talking about something that affects your ability to contribute to society? No. Once those two questions are answered, the other two, the court said, are sometimes important or sometimes not important. They certainly didn't have, political powerlessness certainly didn't have much to do with the decision in 1975 or so to make a heightened scrutiny apply to gender discrimination for the very first time. During the height of the women's movement, when we're dealing with a population that's well over 50% of the entire population, they still were given heightened scrutiny. So that whole scenario tells you that suggestion.
Wasn't that in part because many of the laws that were being challenged were written before women either had the right to vote or actually exercised it in any considerable
Exactly. There's a whole history of disenfranchisement of women and of
which
and
had
of blacks.
ended, had ended 80 years earlier.
Well, as Alan pointed out, there's still lots of laws on the books.
That's the argument.
I think
there's a lot of laws on the books
but look,
before gay people got all of this sudden political prominence too. I mean, the laws we're talking about were written at the time when you would say that they didn't have any political power.
The question is whether there's disenfranchisement at all comparable. There's none, of course, but comparable to what blacks and women experience. There's nothing of the sort. And the standard that I use from political powerlessness wasn't my own. It's from the Supreme Court opinion. So Paul can ridicule if you want, but it's not mine.
I do want to raise the question of surely the political power of the gay and lesbian community has increased substantially in the last 15 years. No question about that, is there? Indeed, that's one of your points and one of Paul Clement's points.
A friend of mine who recently left a major law firm partnership in this town says that you cannot be at a law firm these days and oppose same-sex marriage at a major D.C. law firm. So clearly, I mean, and you look at how Paul Clement had to leave his law firm.
Well, I think that was for a somewhat different reason, because they hadn't cleared the case.
Oh well, if you believe that, Alan.
Well,
yeah.
I believe a lot of things. Yes, okay. But Ed, DOMA was passed in 1965.
1996.
96. Excuse me. Pardon me. Should we judge DOMA on the question of political powerlessness as of 1996 or as of today?
Well, we are.
I mean, if we're worried, the theory is that you measure the degree of scrutiny based upon the ability to affect a legislative process, not just simply to be heard. They weren't very powerful lobbies back in 1996, were there?
I actually think they were, but Alan, the more important point is that you look to now, because now is when the political power is available to be exercised to enact same-sex marriage laws in the states, to repeal DOMA, to do a whole host of other things. It's precisely why, rather than going to this highly divisive, contentious approach where you have the court impose, in these cases, some sort of one-size-fits-all solution that is the equivalent of another Roe versus Wade. And if you like that, you could have another decades of disruption of politics over this. We let this be worked out through the genius of our system in the different states and by the federal government, revisiting this over time, where we can all make arguments to each other about how things ought to be, and not just have 5 of 9 people decide what impose some brand new right on us.
It's easy to say to all the people living in all the states where they have absolutely no protection from employment discrimination, housing discrimination, absolutely no recognition for their relationships, protections for their children that come from that kind of recognition, and no real hope of having any of that change anytime soon. That is the reality of the situation. If you go state by state, you're going to have 50 years of waiting for people to get those basic kinds of equality. And that is the reason why civil rights movements are entitled to go to the Supreme Court and say this kind of discrimination ought to be taken off the table, that it is not acceptable. It is not justified under the standards that apply. And so that's what the plaintiffs in the DOMA case and the Perry case have done. And of course the DOMA case is even weirder because these are people who were married in their states. Marriage is passed in a lot of these states.
In Canada, actually, and contrary to what Alan said, it's unclear that the state of New York would have recognized that marriage. It's actually a disputed question.
But it is. No, it's argued. Well, there are people who dispute it.
Well,
but there are
the House.
They're not the government of the state of New York, though. I mean, that's pretty much a settled question.
Or the IRS.
It's not settled whether back in 2009 when the woman died.
That may be.
But in any event, there are plenty of people who are duly married under the laws of their state. No question. The Gill plaintiffs, for example, the First Circuit case.
Right.
All of those.
And why should those people have to come to the Congress and say and win a majority of all the representatives of all the other states in order to be treated with minimal dignity by their own federal government when their states have married them?
Well, I think that's question begging as to what minimal dignity is. This gets into the whole question of exactly what DOMA does, which perhaps we can turn to.
I'm going to turn to it in just a minute. I want to do two things first. First, I want to ask Paul, the plaintiffs in DOMA are asking for some form of rational basis with bite or some kind of somewhat higher rational basis review.
Right.
Is there any basis for doing it rather like having your steak medium rare as opposed to rare or medium?
I wrote a whole brief about this in the Windsor case. So I remember I talked about the 2 levels of scrutiny, and then I suggested there was kind of this emerging intermediate.
Well, there's the intermediate scrutiny for gender, and then there's something in between those as well.
Well, if you go back to the Romer case and the Cleburne case and the Moreno case and other cases, there are times when the court says we're applying rational basis, or at least doesn't say we're applying anything else, but they are more likely to be skeptical of the justifications. And that's in situations which are somewhat parallel to the same criteria that apply to get you into heightened scrutiny land, which is to say there's a fairly good reason to think that this is a law that was passed based on animus or prejudice or ignorance, and that the proffered justifications are pretextual. And so in Cleburne, they kept the group home for the mentally retarded out of the neighborhood, and they pretended it was a traffic concern and those kinds of concerns, and it was obviously pretextual. So they said, well, we're not going to make disability a discrimination category that gets heightened scrutiny, precisely because we want to have lots of things where we treat the disabled specially. We're going to still throw this law out because it just smells bad. And then Romer was the Amendment 2 from Colorado, which enacted by popular vote this vast ban on any protection for gay people in the state of Colorado. Similar approach. Those kinds of cases, whether you call it a different fourth tier of scrutiny or you simply say, as I think is probably better, rational basis applies, but it applies in different ways in different circumstances where you have different kinds of concerns about what was really going on. That is what the Supreme Court, you can like it or not, that is what the Supreme Court has done.
I'm going to let Ed give a chance to respond, and then we're going to take a short opportunity for audience to ask questions about what we've come to so far. Recognize that we're going to get to the other questions about the defenses and justifications in a minute. So if you'd like to get a question in, come up to the microphone over there, Ed.
Well, I would just say very briefly that Paul's discussion, I think, illustrates the incoherence of the court's approach to these things, the lack of intellectual integrity to these standards of review, and is all the more reason why I think that we ought to expect the court to exercise judicial restraint and return to genuine rational basis review.
Let me just comment, though, Alan. It's difficult to have a debate about something if we're not going to start with the proposition that all the existing Supreme Court case law is what we're working with. I mean, to come in and say, well, the court's got all the equal protection law messed up, and therefore they shouldn't help gay people. That doesn't.
Well, Paul, you didn't like the passage I cited from the city of Cleburne, so
well, it's not the law. I mean, it is a passage in one case, but it's not the way that criterion has ever been applied in other situations, and so.
I'm happy to discuss the law as it is, but that doesn't mean I have to say that the law as it is coherent. Just as you obviously don't believe that the law as it is coherent, because the law as it is does not recognize gays and lesbians as a suspect class. You're trying to change that.
All right. Any questions for the audience? All right. We'll proceed then. So I want to next turn to the justifications, and the question I want to ask first of all to Paul and first to Paul and then to Ed is, should we look at these justifications as being the same and applying the ones I've listed here, which I think are the principal ones that are in the program as well? Are they the same ones that apply equally to both the Prop 8 challenge and to the DOMA challenge? Paul?
Well, some of them only apply to DOMA. This uniformity, which at least as I understand what you mean by uniformity, is really just a justification for the Defense of Marriage Act.
And by uniformity?
Well, as I understand what that argument is, it is that for simplicity's sake, the federal government doesn't want to have to distinguish between married gay couples and unmarried gay couples, and that it is easier for them simply to treat all gay people equally badly as unmarried, even if they're married. And therefore...
They might put it a little differently, Paul.
But,
they might say they don't want to have to treat different...
They don't want to just... What they really say is, there are lots of gay couples who wish they were married or aren't married, and they're not going to get the benefits of all of this stuff, of being treated as married by the federal government, and therefore, in order to treat all same-sex couples the same, we're going to treat the married ones and the unmarried ones the same.
Paul, that's not. It's uniform eligibility for federal benefits for married spouses, and what Congress said in the Defense of Marriage Act, and what the interest here is making sure that that a married couple in Texas is treated the same as a married couple in Massachusetts, with the federal government providing the substantive definition of marriage, so that it's uniform throughout. So
there's two categories of married people: the ones that get in and the ones who don't get in. So we're distinguishing among married couples based on whether they're same-sex or not. And the reason that the uniformity is that they want to be uniform treatment of all same-sex couples, whether they're married or not. That's what the argument is. The government's been making it. Mr. Clement's been making it. That is their argument. I don't think it's a very strong argument.
But isn't there an administrability argument, Paul?
Well, that's a different argument.
Well, it's the first cousin of uniformity. That is, if we have a uniform set of rules, then we don't have to worry about whether somebody is married in one state or another.
This is the people move around argument, which is the idea that it's going to be confusing if we don't have a Defense of Marriage Act that says gay people are out from being treated as married for federal purposes, because some people who are married in Massachusetts are going to move to Texas, and there's going to be and the state of Texas has some authority under the Constitution to not always recognize other states' marriages if they're against the state's public policy. So some states marry first cousins, other states won't recognize those marriages, common law marriage, etc. And that if we start having people move around who are married or same-sex couples, there will be some confusion created by that. The answer is that this kind of situation has been arising for decades and decades as other kinds of couples move around, and that federal law has various choice of law provisions in it about when you're treated as married. If you live in a state that doesn't recognize your marriage, sometimes you'll be treated as married for federal purposes, sometimes you won't. It depends on the statute. But more fundamentally, I would say, whatever concerns you have about people moving around into states where their marriages are no longer recognized, it's a blunderbuss to say we're therefore not going to recognize the marriages of any same-sex couples, including the vast majority of people who get married in Massachusetts and stay in Massachusetts. The much simpler solution is to have a much cleaner, if you want to, choice of law rule that says where you got married is what counts, or the law where you now live is what counts for all purposes. You could have a very simple rule that solves the administrability problem if there is one, but even though they've been dealing with this problem for many years with other kinds of married couples. But you certainly don't want to deny equality to the vast majority of married same-sex couples who don't have any interest in moving to the state of Texas where they're not married.
The reality is that there is no substantively neutral position available to the federal government in defining marriage for purposes of federal law. Whatever definition it takes, either subsidizes same-sex marriage or refuses to subsidize it. And what Congress decided back in 1996 was the simple matter that it was going to stick with the traditional definition of marriage, the marriage that had always been understood to exist in provisions of federal law. It was codifying it against judicial reinvention, and that interest, again, one can disagree as a matter of policy and say, no, look, we prefer to subsidize same-sex marriage, but when there is no substantively neutral position, when you have to go one way or the other, it is permissible for Congress to have gone either way. And it went against subsidizing, against forcing the taxpayers, the federal taxpayers of states that don't have same-sex marriage, to subsidize the same-sex marriage experiments in those states that do.
The irony of that argument is that every indication, including a study by the GAO, is that it costs the United States money not to recognize the marriages of same-sex couples that are married.
But why should that be, Paul?
Because of tax consequences, welfare. When you treat people as single when they're married and they're living in one household, but they get treated as single for both welfare purposes and tax purposes, it just ends up costing more money net. Obviously not in every case for every person, but net it does. And there was a proposal made at the time DOMA was passed to do a more thorough study of this issue, and it was voted down. So the idea that the word subsidy, I think, is the wrong word here. There is no financial net benefit to the same-sex couples. It's the net benefit would be to recognizing these marriages would be to the federal government.
Well, those studies are very much contested.
Well, there's no other study in the record on any of these cases, other than the Congressional Budget Office study.
No one has tried to put any evidence in at all to the contrary of that.
I mean, there are questions raised about it.
It's perfectly reasonable for Congress to make long-term assessments about, and whether or not, even apart from the subsidization questions, the whole question of whether Congress should be endorsing this same-sex marriage movement by permitting the redefinition of spousal marriage under federal law.
I agree. That's a justification. It's a different one. But I want to ask you: wouldn't Congress be able to achieve the same kind of uniformity by saying we uniformly apply the law, as Paul suggested, in the place of marriage? That would be uniformity. It would be horizontal. It would be a different kind of uniformity if uniformity was the question. If that was the only value at stake.
I have no doubt that there are different aspects of uniformity that Congress could, in different circumstances, reasonably choose to pursue. Each of those is a permissible option.
Is there any uniformity argument? Do you agree with Paul? Maybe we'll get one item of agreement that uniformity is not an issue in the Prop 8 case.
I think that's right. Well, there actually is.
I thought I was actually going to get agreement.
There is an argument that the plaintiffs challenging Prop 8 make about the existence of the 18,000 or so same-sex marriages that occurred in California between the time of the state Supreme Court opinion inventing the right to same-sex marriage and the effective date of Prop 8. But
that's not an issue in the Perry case itself, is it?
Plaintiffs have argued that there's some sort of irrationality in Prop 8 in permitting those permitting those marriages to continue. So that's a
but I mean, in terms of
uniformity
it's not the same kind of definitional uniformity problem that there is at the DOMA.
I agree.
Okay. All right. Now, second, it's often said that one of the reasons that states on the one hand and the federal government on the other did not grant the right to marry in the case of California, or grant the right to have the benefits and whatever burdens there may be in the case of DOMA, because the voters in California and the Congress in DOMA were acting out of caution. They wanted to maintain the status quo. I think that was a phrase you used before, Ed. Is that a view you think is helpful to your side in either or both of the cases?
Well, when there's a debate, as I think there fairly is, over what the long-term consequences of redefining marriage would be, and I think that's an unknowable matter. People can reasonably forecast, but I think it's ultimately unknowable. It's, I think, eminently sensible for a state or the federal government to say, well, why don't we learn a little bit from what's happening in those jurisdictions where it does happen? Why don't we hold back and see? Why don't we, rather than rushing to this latest new fad, why don't we actually think through this and learn lessons from what's happening in other places? I think
Paul, two questions. One, is caution a value that we should approve of? And second, was there caution in either or both of these laws?
I think if you're going to use caution as the justification, you have to have articulate something that you're being cautious about. What are you worried about? And just saying...
Long-term consequences is what Ed said.
Well, long-term consequences is another way of avoiding what you're saying. What are you saying?
Thank you. Let me spell it out, because so much of this discussion has completely, again, has just avoided addressing what marriage is. And the threat that I see is the permanent collapse of the marriage culture in this country. Let me be clear. We're already in a state of collapse of the marriage culture. That is a collapse that heterosexuals are responsible for. Same-sex marriage is not a cause of that collapse. It's much more a symptom of it. But if we understand the importance of linking marriage to procreation and child-rearing, we understand that the goal ought to be to maximize the possibility that children are raised in stable households by the father and mother who gave rise to them. Then we ought to be wary, very, very wary of redefining marriage in a way that completely reorients it away from its core mission. It takes out of it this essential element, the male-female component. That is what marriage has been all about. I think it's quite phenomenal. I guess many of you are too young to realize this, I suppose. But 15, 20 years ago, I think Paul will agree with me on this. The idea of same-sex marriage was let's just say not widely accepted, as distinctly minority position.
I'll give you that.
And we have had, and to now again, one can view this in different ways, and it's a testament, I think, to the political power of gays and lesbians that there's been this transformation. But I think it also ought to invite caution on the part of people. Do we really know what happens when we redefine marriage in such a fundamental way? You look at all the social pathologies associated with out-of-wedlock births. Again, this is the problem of heterosexuals. The cause, I make that clear. But if this country is going to survive 30, 40 years from now, probably the most important thing is to fix our collapsed marriage culture, not to redefine marriage completely away from its central purpose.
This is the famous irresponsible procreation justification.
I want to get to that in a minute.
That's why we have marriage.
Can we talk about caution? Do you think that what not about inappropriate procreation caution, but other kinds of caution, legislative caution, right?
Well,
Do you think it's fair to describe this as caution?
Well, certainly not DOMA. I mean, we're going back.
Let's talk to DOMA for a second. Okay.
It's one thing to say you're going to pause as they passed this law. Hawaii was talking about being the first state to have same-sex marriage, and pause and study the issue, et cetera. You pass a law though that has no termination on it, and
was there a proposal to have a sunset on it?
There may have been. I'm not sure.
It could be amended any time. It's a simple federal law.
It could be, but it's now been on the books for a long time, right? And so the question is, at what point do you let Congress continue to say, well, the people defending the law say, well, they were being cautious in 1996, so now in 2013, that's the justification which will allow continued discrimination, despite, for example, the last decade of experience we have with same-sex couples marrying. And the reason why people's views about this are changing so dramatically is they've been able to see exactly what that means, not only to those people and to their families, but to the community that they live in. And the idea that this is going to somehow unsettle society and make marriage for straight people less desirable or less believed in just because more people want to buy into the concept of marriage has proved, I submit, to be sort of fanciful.
Well, I think it's fanciful to think that one can draw conclusions from 10 years or 17 years worth of of data. I mean, plaintiffs' experts plaintiffs' experts in the Prop 8 case say there's no way you can draw conclusions about what will happen to marriage. They say that themselves, but somehow the advocates think that they can play social scientist and contradict what their own experts are saying. This is a matter, if taken seriously, this is a matter that will take decades and decades and decades before you're able to draw any reasonable conclusions, if you even are then.
And what does that mean in terms of changing the law?
It means it is entirely reasonable for Congress to maintain the Defense of Marriage Act. It's, of course, entirely permissible for Congress to revise it. This is not something that the court has any proper role in intervening in.
Do you think it matters in the case of California that California has had domestic partnerships for some period of time? That is to say, if these are consequences that you're worried about, wouldn't those play out in the era of domestic partnerships between same-sex couples as well as between opposite-sex couples, and wouldn't that allow for some kind of understanding as to what's happened?
Well, again, I think it's only been, I believe, Paul can correct me, since 2003 that California has had a full, robust domestic partnership laws. Yeah. But Alan's point, I want to make sure that, draw out Alan's point. The fact of the matter is, it's agreed by both sides that the robust domestic partnership regime in California is akin to what's called civil unions regimes elsewhere,
yes,
that affords all the rights and incidents of marriage to domestic partners, but it does not give the name.
Right.
Now, Alan, you said earlier that domestic partners can't call themselves married. They can call themselves whatever they want. The point is...
Well, they can't call themselves married if they apply for a passport or...
Okay.
Well, even if they're married, they can't do that if they're same-sex couples. That's what the Defense of Marriage Act
Well, they
does.
can call them that.
Right,
They can't
No, it's a federal crime.
Is it a federal crime to apply
to
for a
say you're
passport
married
and
on a
say
federal
married?
form if you're a married same-sex couple? That's one of the great horrors of DOMA. You put that down on your tax form.
Well, I think there'd be a mens rea question there, of intent. But let's... Alan, everyone, again, people on both sides agree that the word marriage matters. The gays and lesbians see it as a deprivation of some sort of recognition. But I think those of us supporting traditional marriage see that the word marriage draws on its traditional role in this role that's tied to procreation and child rearing. And if we want, men and women to understand that marriage is the ideal context in which to raise children, it makes no sense to redefine marriage in a way that eliminates its essential component.
So this is here you have a choice. You have a bunch of people who are out there, same-sex couples, raising children right now, can't get married. If you think marriage is an important thing to have in your parents, you would think they would benefit from having married parents. Lots of rights that come with that, protections, et cetera, et cetera.
Well, we're assuming in California they've got all the rights except the label,
well,
right?
but even then they don't get any federal rights, right? So,
Okay, well, that's a separate question.
But there are two separate.
Let's keep it separate.
But the point is, in most states right now, they don't get anything, right? That there is no relationship recognition at all. And so, in order to avoid the speculation that straight people are going to be more likely to have children in their household without being married, we're going to keep the children in these other households without their parents being married. Now, how do you make that calculus? I don't understand it. It seems to me the notion that straight people are going to have more kids without getting married because we're letting gay people get married is rank speculation at best. It's almost kind of offensive when you think about it, that people are so unhappy with gay people getting equality that they're going to stop going down and getting married at the chapel.
That's not the argument, Paul.
So far, what is the argument?
Okay, well, first of all, let me agree with you that in the policy calculus on whether or not same-sex marriage should be adopted, I agree with you that the interest of the kids being raised by same-sex couples are a factor in the calculus. The argument is not that people are going to be offended by same-sex couples. The argument is that the redefinition of marriage away from its core component of male-female says marriage isn't about procreation at all. Marriage isn't the vehicle in which you should raise your children. This doesn't matter. And you have millions and millions and millions of existing and potential victims of the collapse of our marriage culture. Again, heterosexuals are responsible for that collapse, But if we don't restore that, this country is doomed.
And you think that applies the same whether you have civil unions, domestic partnerships, or an institution called marriage for same-sex couples?
I'm not.
In other words, you think that the tipping point is when it's called the institution is called marriage, and that's going to cause opposite-sex couples to not get married?
I think the redefinition of marriage is a significant defining point. I'll also add, though, there's this sort of inconsistency in the arguments that I hear from the other side, in that on the one hand you hear that this is schlock science, it turns out, but you hear that the kids of gays and lesbians by any measure do as well or better than anyone else. And on the other hand, that somehow they're so, and this is not married gays and lesbians, this is just couples, but that somehow they're so hurt by the deprivation of marriage. The two are difficult, I think, to connect.
Well, the inconsistency is your side saying, well, marriage is the most important thing. We don't want kids being raised in households by two parents if they can't be married. Because that's the harm. It's illegitimate children living with their parents is the harm that's being held out there, which is exactly what's being inflicted on the gay community because they don't have this option of being married. And so that is the real inconsistency.
So I want to ask sometimes what's referred to as what's the big deal question in California. So if gays and lesbians have all of the rights except being able to be called married,
Yeah.
and they say we want to be called married, and California, by definition, has given them all the legal rights. So what's the big deal? Or indeed, who has the burden of showing what's the big deal on this?
Well, I'm sorry.
You didn't assign it. Somebody
I'll ask you to go first, Paul.
It seems to be the first conclusion you draw from that state of affairs is that there's only one remaining potential justification, once it's only a semantic distinction for what the state is doing and withholding the use of the word marriage, and that is to maintain the idea and the message that same-sex relationships are less valuable, less worthy, and that these are second-class
How about moral disapproval? Is that?
Well, that one's off the table. That was off the table. We won that case 10 years ago.
Well, you won it in the context of a criminal case of justifying on moral disapproval.
This case stands for a lot more than that. It says
well, we will see. You may be right. You may be right.
Well, I'm only quoting Justice Scalia in his dissent in the Lawrence case.
You think he's going to be bound by that, Ed?
I don't think he's going to be bound by that.
I don't think so.
I would be very surprised if Justice Scalia found himself bound by his...
His reading of the majority opinion was quite accurate, though, in terms of what it stands for on the moral disapproval justification.
But in the context of a criminal... It was a criminal case, right?
Yes, it was.
Okay. All right. So it certainly was. Ed, moral disapproval, what's the big deal? Where do you stand on those?
No, again, people on both sides agree that the word marriage matters. I don't agree that it matters for the reasons Paul says. I agree that it matters because we have this concept of marriage as it existed throughout Western history, throughout world history, of a man and a woman, and it exists for a purpose. And I'm repeating myself, but I guess...
To whom does it matter?
To whom does it matter? It matters to society. In order to encourage men and women to have and raise children in the best context possible.
So that's why the proponents are injured, so to speak, by the non-enforcement.
Well, the injury question, Alan,
I'm trying to understand the societal injury.
If you're trying to tie in the standing question, that's again, the proponents are standing in the position of the state. So you would no more ask how is the state of California injured. You wouldn't need to. The state has an interest in defending its law, and the California Supreme Court has said that Prop 8 proponents are asserting the interest of the state. So it's not a matter of the Prop 8 proponents' injury, but it's the concern is about how society and the institution of marriage will be damaged by this radical redefinition.
Do you agree with Paul that moral disapproval is off the table after Lawrence? As a justification, that is, the state says we are not going, we were not going to criminalize homosexual activity. We realize we can't do that, but we disapprove of it, and therefore we are not going to allow same-sex couples to call themselves married because we disapprove of it.
I think Paul may well be right. I think moral disapproval has nothing to do with the sound bases for defending traditional marriage. And, you know, are there some voters who may have voted for Prop 8 because of moral disapproval of homosexuals? Are there some voters who voted against Prop 8 because of moral disapproval of conservative Christians? It cuts both ways. I mean, of course there are people who are going to have mixed motives. That can't be, I mean, the court's not going to be trying to, you know.
And how about in DOMA? Do you think that the statements on in the House report and on the floor are off the table? That is not, the court may not, need not, should not consider them?
Well,
insofar as they express moral disapproval, they're of course pre-Lawrence, so that has something.
Right, and of course a lot of this is going to tie into which standard of review the court ends up adopting. But I think that when you have plenty of statements in the congressional record discussing the importance of uniform eligibility for benefits, it'd be some sort of weird cherry picking to say, we're going to give decisive weight to these 1 or 2 or 3 statements here that we don't like.
1 or 2 or 3? Oh my goodness!
You think that,
the place is replete with just the expressions that homosexuality is something that ought to be condemned and has been condemned, and that's why we're passing the statute. And it was said day after day in that debate. This is not. You know, there may be other statements about value of uniform eligibility for benefits. But that was not the gist of that debate.
Well, have in mind that there were lots and lots of gay rights supporters who voted for the Defense of Marriage Act, people who back then had strong records of support for gay rights, people like President Clinton who signed it into law. I think the numbers are something like, I have them here somewhere, I don't know, 87 to 13 in the Senate and comparable in the House. The idea that animus against gays drove the adoption of DOMA, I think, is not
the fact that it was an election year and gay people don't have the political power to protect themselves may have had something to do with it.
All right, so I want to move off the justifications a second and ask whether are there any in DOMA first, Paul? Are there any intermediate positions between striking DOMA down entirely and upholding it? Do you see any?
I don't think so. No.
Do you, Ed?
No, I don't. In fact, I think, Alan, that that both cases essentially present the same question. You said at the outset that they're different cases, and of course they are different cases. But I think ultimately the question is, you know, do the states have the authority to retain the traditional definition of marriage, and may the federal government in its realm retain that definition? Not that they have to. Again, they could revise their policies, but may they? And I think it's the same question in both cases.
Are there, not asking you to yield your position on that, but are there any interim positions in the Prop 8 case that the court could find between, on the one hand, doing what Ed has suggested, which is to say that the states have the full power to uphold or to change or do anything with same-sex marriages, and what the strongest view of the challengers is in Prop 8, that all laws distinguishing between same-sex and opposite-sex couples are unconstitutional. Is there an interim position in that case, Paul?
Several.
Okay.
Several.
You want to give it to?
One is the standing argument, actually. That if you
well, it's not an interim position. I meant to say on the merits. They could duck it, right?
Like it would be ducking it in a weird way, because it would probably mean, as a practical matter, that there would be marriage equality restored in California. But at least that's a possibility.
Why would that be?
Because the district court opinion and judgment stays in effect. There's no question that was perfectly validly entered as a matter of Article 3.
But that applies to the 4 plaintiffs clearly.
Well, I don't think that's clear at all.
Well, it at least applies to them, right?
Well, more than that, though, I think.
And what do you think
will be argued anyway?
What do you think the governor will do?
You know, I think as a practical matter, the next day there would be wedding bells ringing all over the state of California, probably. But
it wouldn't be the Supreme Court's fault, right?
No, they have nothing to do with it. In any event, on the merits in the Perry case, there are the narrower grounds, which were basically discussed by Judge Reinhardt in his Ninth Circuit opinion, and one of them relates to the fact that, as we've already discussed, California created a separate institution of domestic partnership and made it legally identical to marriage as far as state law goes. And the argument would be that a state that has done that, unlike a state that doesn't do that, has essentially disclaimed any really meaningful state interest in continuing to withhold the use of the M word for same-sex couples, because there's essentially only what is left is the drawing of distinctions based on second-class and first-class relationships. there's no real meaningful distinction there. That would be an argument. That would be the so-called 8-state solution. I've never actually done the count, but that seems to be what's floating
Meaning
around.
that there are 8 states that have civil unions or domestic partnerships, but not marriage,
Right.
like Massachusetts and New York.
And
now,
you could, the
Maryland.
court could decide it that way and leave for another day the question of whether the other 25 or 30 states have to give marriage equality someday. The other one would be California granted it and took it back, and that
That's what Judge Reinhardt said.
Well, he did both of those arguments, actually. If you go back and look at the opinion,
but-
he kind of wove them together in a complicated way.
Complicated is a nice adjective.
Yes, all right.
Look, I agree with.
Those are possibilities.
Yeah,
Right?
no,
Yes.
no, I agree. I agree with Paul that those are the two lesser alternatives, so to speak, that plaintiffs have urged. I don't think either is coherent, but the court is not always driven by coherence.
Interestingly, the defenders of DOMA and of Prop 8 both herald how the world has changed since DOMA was passed and in the last 20 years all over in terms of gay rights and so forth, and how regardless of what power gays and lesbians had in 1996, they surely have more power now. And that argument is invoked at the conclusion of the reply brief of both Chuck Cooper, representing the proponents of Prop 8, and of Paul Clement, representing the House in the DOMA case. What kind of impact do you think that clear change in the political world is likely to have, or maybe should have, if you want to, either way you want to answer it, in terms of what impact it's going to have on the case?
Well, I'll pass on what impact it's likely to have, since that involves some psychologizing of the justices, which I find to be an unpleasant experience. In terms of
You're going to pass on that.
In terms of what impact it should have, I think, again, it makes manifest that rather than imposing on the country another Roe versus Wade, this is a matter that is being addressed through robust democratic debate. That debate will continue. I have no illusions that my preferences are going to prevail everywhere. Paul, may have no illusions that his will prevail everywhere. But
In the legislative or initiative process.
yeah, but the genius of federalism is things work out so that it satisfies more people's interests more of the time. And more than that, there's just a sense that this has been a fair fight. And also, this hasn't come up yet, so let me mention this. The legislative process is also far better at coming up with, say, accommodations, protections for religious liberty, all sorts of compromises than the judicial declaration of a right, which, if you read, Ted Olson's brief, that anyone who supports traditional marriage is the equivalent of a
You
rape.
think he precludes the accommodation kind of statute you refer to as in New York?
Well, look, if you have, the very rhetoric says that the position that President Obama himself had till a year ago is that position is akin to racial bigotry, and we know how to deal with racial bigots in this country. We marginalize, stigmatize, penalize, deprive them of all sorts of opportunities, and that is the path on which things will be headed quite quickly. Some people may welcome that. It's not going to provide social peace, and I don't think it'd be good for this country. But if there is a declaration of a fundamental constitutional right to marry a person of the same sex.
Paul, you want to comment on that? And in particular, would you talk a little bit about the Roe analogy, if you mind?
Yeah, let me get to that before.
Sure,
but first,
as you choose.
I think it's sort of unknowable how, as a psychological matter, the greater success of and the change of popular opinion will have on the justices, because you have one hypothesis, which is that the Supreme Court follows the election returns. That's a cliche, and then that they will be comforted by the fact that they aren't getting too far ahead of the American people if they recognize marriage equality as a federal constitutional right. And then you have the alternative, which is being strongly argued by the other side, which is this is just the moment not to get involved because everything's going swimmingly for the gay community, and just let them keep swimming. I think there's no way anybody could tell what will affect which justice which way on that. In terms of the Roe v. Wade specter out there, the so-called backlash and the creation of a generation of continual war over this sort of thing. My own supposition, and I think this is backed up empirically, is that these issues, abortion and marriage for same-sex couples, are fundamentally different, and that because, unlike with abortion, there is no victim that people believe is being murdered, that people very quickly accommodate themselves to allowing everybody to have the same opportunity to enjoy the benefits of marriage. And you've seen this in state after state, where, for example, the conservative Republican establishment of New Hampshire has turned the other way on this issue, and people just calm down after a couple of years. And you know, if the Supreme Court were to say everybody has a right to marriage equality across this country starting on June 28th, there will be some hubbub about that. But I don't think it's going to be remotely comparable to the Roe v. Wade situation.
I think Paul may well be right that the aftermath of a Roe-like ruling would be very different in the context of same-sex marriage and an abortion. I think it would play out over the decades primarily in attacks on traditional religious believers, deprivations of their rights. For example, can you qualify for a grant or a scholarship? Can you get a government job if you hold this position that suddenly is declared akin to racial bigotry? So I think it would be a very contentious, divisive process, but I agree with Paul that it might well play out in a very different way than the Roe debate has played out.
Paul, you want to say anything about the accommodations? All right, audience, next chance for questions. Whoa, all right.
Let me get this out there right away. Thanks. Mr. Whelan,
Whelan,
I pronounced that right? Whelan, for being here. I get the sense, just from seeing the amount of young people in the room, that you may be in the minority. I'm just guessing, but I'm glad you're here because young people really don't see what is the issue. But that said, some people may even say, "What's the big deal about getting married?" But that's a whole other radical thing, and I won't get into that. What's the benefit of marrying?
We only
been
have
married?
10 minutes
Okay,
left.
my question
so please,
is:
we got to keep
you
our
talked a
questions
lot
short.
about tradition, caution, and a radical notion. How does this relate to the precedents of miscegenation and Loving versus Virginia?
All right, let's have a couple of questions, the next two people as well, and then we'll have the panel answer those, and then we'll get the last people who are in line as well.
My question is for Paul Smith, and it is, what is the primary purpose of the federal government incentivizing marriage in the first place for anyone? And if same-sex couples can show that they are able to fulfill that purpose, what is special or unique about same-sex relationships that should preclude the federal government from incentivizing any and every other relationship that can also fulfill that purpose, such as brothers and sisters that want to live together and file a joint tax return?
Commentators have compared the court's decision this week to decisions such as Plessy and Brown and their significance to the African-American community. How do you think the court will weigh that the legacy of those cases in their decision in the cases this week?
Okay, three great questions. My panelists will answer them in whatever order they want, whichever ones they want.
Well, why don't I address the Loving question, and Paul, you address the second one? And,
Okay.
Look, the ugly anti-miscegenation laws were always recognized as a departure from the traditional understanding of marriage. They were phrased that way. They were not in every state in this country. They were impositions of a restriction on top of what marriage is. By contrast, the male-female component of nature has inhered in what marriage always has been, and it involves a radical redefinition of marriage to say that it's not a male-female union.
The question involved the sort of idea that the federal government has long had a history of incentivizing marriage, which I think is a complicated one and makes the question hard to answer, because the basic posture of the federal government throughout our history has been not to do anything about marriage except accept state decisions. Now, there are some benefits that help married families and or widows and things like that. There are some taxes which go up when you get married. So whether the federal government actually encourages marriage economically or not is, I think, a complicated question. But then the question went on to say, well, why shouldn't whatever that is apply to people who want to marry their family members incest-wise and stuff? And I think whenever you start getting into these sort of parade of horribles, whether it's the incest one or the prostitution one or the polygamy one, you have to take into account that there are lots of other interests at stake. And incest, I think, is the clearest example of that. When the reason why the law prohibits people from marrying their sister is there are both psychological and physical health reasons why that is an inherently unhealthy situation, and the state has a legitimate interest unrelated to anything we've been talking about today in regulating that relationship.
But Paul, how prejudiced of you to deprive adults who believe that their happiness depends on marrying their siblings from being able to do so. You're imposing your own morality and disapproving that. I think the questioner
I didn't say anything about morality at all. I was talking about health. There's state interests.
Psychological. Okay. Well, if they want to make the judgment that they're willing to take those risks, who are you to say they can't under your own logic? Polyamory. One other brief point. Polygamy is not to raise polygamy is not a slippery slope argument, because as a matter of history, polygamy is up the slope from same-sex marriage. We've had plenty of examples of polygamy throughout history, and I would say that the distinction between 2 and 3 is much less arbitrary and much less removed from the core purpose of marriage than to redefine marriage to be a same-sex union.
All right, gentlemen.
We had a question about Plessy and Brown and how they're going to be
legacy.
The legacy of those cases. I mean, it seems to be, whenever you talk about these sort of landmark equal protection cases, that whole story of Plessy and separate but equal, and then how it was recognized that the separate but equal concept was inherently problematic, is sort of lurking in the background here. And it's the whole notion that California has, we're going to have these two different institutions, we're not going to let them call them the same thing, is very resonant of the separate but equal concept.
Well, again, I'm not going to try to psychologize the justices, but I wish they would spend more time getting the law right and less time, worrying about what their legacies might be.
Thank you. I'd like to just ask Mr. Whelan. We were talking about political power earlier, and the argument was brought up that there are specific classes that have more political power presently but still have heightened protections, such as racial groups. The president is African American, and women who control 20 seats in the Senate, for example, still have heightened protections. Should those protections at some point be taken away when they are deemed to have enough political power?
That's a very interesting question on which I have no view. Largely because I'm a skeptic of the legitimacy of a huge part of this heightened scrutiny enterprise.
Thank you. Michael.
Thank you all for being here. Some opponents of marriage equality say that same-sex marriage bans aren't discrimination because straight men can't marry men and gay men can't marry men. Just as in Loving v. Virginia, opponents of marriage equality for interracial couples said, well, it's not discrimination because blacks can't marry whites and whites can't marry blacks. How would you respond to those arguments?
Paul?
That's the kind of argument that is made in all of these cases, and it's basically just doesn't work. You know, the same argument was made in Lawrence that the Texas homosexual conduct law didn't discriminate against gay people because it also prevented straight men from getting together with other straight men and having sex. It's equally idiotic, frankly, it seems to me. The law very specifically targets a group of relationships which are of people who have same-sex sexual orientation and have formed these marriages or want to form these marriages in the case of the Perry case. And there's no serious argument under the law as it now stands that both of these cases ought to be analyzed as discrimination based on sexual orientation. The court's been very clear we're not going to draw a distinction between conduct and status, that gay people have both a conduct and a status, and they're a group of people, and we're not going to let that argument work anymore. So.
Well, there are many supporters of same-sex marriage who argue that traditional marriage laws are better understood as discrimination on the basis of sex rather than sexual orientation, that is saying a man can marry a woman but can't marry a man. Look, I think these arguments are not the most effective arguments to make because they fail to get to what ought to be at the core what is marriage, what is its purpose. And if you understand that, everything else falls in place. And if you don't,
We'll ask the last two questions to come in, and then we're going to have to wrap it up because we're getting to 5:30, which is the magic hour.
My question is mostly about the marriage institution, and it's mostly toward Mr. Whelan. And by all respect I have for your thoughts, the way that you look at the history of marriage institution, to me, is not a science. It's not an anthropological and cultural science. It's more than anthropological hypocrisy. Because the way that you're saying, if marriage entity's social goal is just to create more human being, then why do we even let people who can't conceive be married? The other side is you're not even letting gay people or homosexual people to be married. Then ask them, why can't you help society? Right now, there are other homosexual couples who are helping this society, but not even being able to marry, and they're raising children. And the third thing that I want to say is that the way that you're segregating our society by saying that just a man and woman can get married, to me is the same argument as, I'm sorry to using that word, Nazis would segregate societies. Like, based on what? Because our social goal of marriage is to reproduce. I mean, I think before societies had been out there, we could reproduce too.
Right,
but let me answer your.
Can I get the last question? I'm sorry, we're going to have to cut you off because we really do need to get down because the time is up for our television. Last question, and then both of you can answer that.
Yeah.
Okay, I'm going to try to speak as quickly as possible. I have a lot of sympathy for Mr. Whelan's argument about letting the legislative process take its course and that this is a judicial power grab. But how do you answer people who say that this is taking too long and all of the gay couples in states where they don't have these rights? How do you answer that, and what's your response to that?
Okay, thank you. Let me briefly answer the question that the gentleman raised. What he calls, I think, my false anthropology is an anthropology that all anthropologists, social scientists recognize. Lefty, people on the left, read through the briefs. This isn't something I've come up with. This was the consensus until it became fashionable to promote this new cause. As for the infertile couple canard, the point is that the tradition of marriage has developed exactly as it has with the opposite sex union. And we don't have Orwellian fertility tests. I think you maybe made some reference to Nazism, if I heard you correctly. I think the fertility tests that you would be contemplating would be very something you'd see in a totalitarian regime. Fertility tests would, of course, be very inexact anyway, as lots of people have discovered. It's not a simple matter. Even beyond that, I mean, the law generally presumes fertility. The fertile octogenarian, yes. And even in a couple that's infertile, there's often one person who is fertile, and the norm of monogamy within marriage ensures that person doesn't have children outside marriage. On the second question from the young lady, the question whether it's taking too long presupposes that there's only one right answer to what can happen in democratic processes. And if the Constitution actually spoke to this question, then it wouldn't be a sufficient answer to say let it be worked out democratically. But since it doesn't, that is what should happen. And it's not a matter of anything taking too long. It's a matter of the people in different states working out over time how they want to address this matter.
Paul, you got the last word.
Let me just say, this is one of those rare moments in history, I think, where a new discrete and insular minority group has come along and made a very fundamental claim that says it is time for us no longer to face these basic forms of discrimination, that the Equal Protection Clause exists for us as much as it exists for everybody else in this country, and that they are entitled to call on the courts to do that, even though we all agree this is democracy and that most issues ought to be resolved democratically.
Thank you very much, both my colleagues. Ed, Paul, thank you so much for coming, and thank the audience for your attention and staying with us this long. That concludes our program.